Okay. And at the time period where they were going to start to discuss, what was Dan Scavino's role?
At the time, I believe his title was social media director for the White House. It became deputy chief of staff at the time that the conversation in question took place.
Okay, and when was that?
The conversation was around December 19th of 2020 at the White House Christmas party. And I emphasized him. I thought that the claims and the ability to challenge the election results was essentially over, because he said to me in a kind of excited tone, well, we don't care and we're not going to leave. And I said, what do you mean? And he said, well, the boss, meaning President Trump, and everyone understood the boss, that's what we all called him. He said the boss is not going to leave under any circumstances. We are just going to stay in power. And I said to him, well, it doesn't quite work that way, you realize. And he said, we don't care.
Ms. Powell, were you ever around when anyone told Donald Trump that he had lost the election?
Oh, yeah.
Who?
Pat Cipollone, Eric Hirschman, Derek Lyons, all thought he'd lost.
Was that in the December 18th meeting?
Yes.
What was President Trump's reaction when, I guess, this cadre of advisors would say you lost?
It was like, well, they would say that and then they'd walk out and he'd go, see, this is what I deal with all the time. He was specifically willing to appoint me special counsel. In fact, he looked over at Cipollone 3 different times and said, do I have the authority to name her special counsel? And Cipollone said, yes, you do. And then somebody said, well, she doesn't have a security clearance. So he looked at Cipollone and he said, do I have the authority to give her a security clearance? And Cipollone said, yes, you do. And then about the 3rd time we went through that scenario, Cipollone, I think, said, you can name her anything you want, Mr. President, and nobody's going to pay a bit of attention to it.
This is former Trump attorneys Jenna Ellis and Sidney Powell during confidential interviews called proffer sessions with Fulton County investigators. And the reason why they're so forthright with these investigators is because they've both entered into plea deals with prosecutors, meaning they've pleaded guilty on a few charges in exchange for avoiding jail time.
Do you understand that by pleading guilty, you are giving up the right to a trial by jury?
Yes.
Do you understand that by pleading guilty, you're giving up the right to remain silent and not to incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the right to confront witnesses that the state may bring to testify against you?
Yes.
Do you understand that by pleading guilty, you're giving up the right to assistance of counsel hired by you or to a court-appointed counsel if you cannot afford one at trial?
Yes.
Do you understand that by pleading guilty, you're giving up the right of the presumption of innocence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to have the charges against you proven beyond a reasonable doubt?
Yes.
Do you understand that by pleading guilty, you're giving up the right to appeal if convicted of these charges after trial?
Yes.
Has anyone forced, threatened, or promised you anything in order to enter into this guilty plea?
Other than what is recited in the documents, no.
How do you plead to 5 counts of conspiracy to commit intentional interference with the performance of election duties and 1 count of conspiracy to commit criminal trespass?
Let's let me approach for a second. We changed, there's the trespass count was changed, so it's all 6 counts. It's 6 counts of the first.
Gotcha.
Okay.
Sorry, thank you. I apologize. How do you plead to the 6 counts of conspiracy to commit intentional interference with performance of election duties?
Guilty.
As an attorney who is also a Christian, I take my responsibilities as a lawyer very seriously, and I endeavor to be a person of sound moral and ethical character in all of my dealings. In the wake of the 2020 presidential election, I believed that challenging the results on behalf of President Trump should be pursued in a just and legal way. I endeavored to represent my client to the best of my ability. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were in fact true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, I failed to do my due diligence. I believe in and I value election integrity. If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges. I look back on this whole experience with deep remorse.
And since those cooperation deals were entered into, we now have some insight into the damning testimony that's being offered by these witnesses. For example, I'm not sure it could be more damaging for Trump than Jenna Ellis revealing that he would refuse to leave the White House despite losing the election, thereby proving that it was never about any legitimate claims of fraud and solely about his insistence on flexing his dictatorial muscles and remaining in power despite his loss. If you were looking for solid proof of criminal intent, you just got it. As for Powell, what she offered is first-hand testimony that, again, Donald Trump was told by his own White House counsel that he lost the election, and yet, what did he decide to do? Barrel forward with his claims that he won the election anyway, despite this irrefutable proof that he was told otherwise. Again, if you needed proof of criminal intent, you just got it. All of which is to say, Trump has zero viable defense here. Again, we already know that Trump will claim that he truly believed that he won the election, and so he just had to do what was necessary based on that knowledge. But given this small sampling of testimony against him, his defense won't stand a chance in front of a jury. Meaning, just in these two clips alone, Trump has no case, and God knows what mountain of evidence beyond this is awaiting Trump in court. In fact, I spoke with my Legal Breakdown co-host Glenn Kirshner about exactly this point, and this is what he had to say.
Donald Trump cannot present to a jury a plausible claim that he thought he won. There's no support for that anywhere, no matter where he turns. Not the White House lawyers who told him he lost, not his own vice president, not his own attorney general, not his own one-time nefarious lawyers who have pleaded guilty and flipped on him. But you know what? I hope Donald Trump tries to present that defense, because the only way he gets to present that defense, because the rules of evidence actually apply once you're in trial, the only way he gets to present to the jury that he in his mind actually believed he won is if he crawls up on the witness stand, is placed under oath, and then prosecutors get to cross-examine him. He's not going to do that. And let me just finish out the discussion of the rules of evidence. The rules of evidence prohibit any other witness from coming in to a prosecution and testifying that, oh, Donald Trump thought he won. That's inadmissible. The only way it becomes admissible evidence is the person who claims he thought something, thought he won, takes the stand and testifies. Brian, Donald Trump has nowhere left to turn, which is why all he does now is attack the process and the institutions and the judge and the prosecutor and President Biden and the witnesses, right? That's all he has left. He has no defense on the merits, on the facts, so he has to try to undermine the process and the people who populate the process and the institutions, because he knows a guilty verdict is coming, and he has to do everything he can to undermine the institutions so that maybe people will be less inclined to accept that guilty verdict.
And this isn't just bad for Trump because it destroys his defense, it is also a blinking red light to the other co-defendants who've yet to enter into cooperation agreements with prosecutors that so long as they remain on the wrong side of the V, as they say, Fulton County v. Donald Trump and the other co-defendants, they are contending with a bulletproof case against them. If nothing else, this leaked footage shows the strength of the prosecution that is awaiting them. And if they didn't want to flip before, there is not a planet on which they're not seriously considering flipping now. Before you go, I need some help. Please subscribe to this channel and do your part to help grow the progressive media ecosystem. I don't do sponsorships or paid ads, I won't ask for money, but just subscribing to this channel goes a really long way, and it helps get the message out to more people. The subscribe button is right here on the screen. You can also subscribe to my Spanish language channel, which I made to reach those crucial Spanish-speaking voters. That link is on the screen too. And finally, if you want to listen to my audio podcast, you can follow that link as well. Thanks so much for watching.